Ladies and gentlemen, now we will begin session 4 under the topic of climate change and challenges to the law of the sea. Professor Jae-hyung Lee from Korea University Law School will moderate this session. He is online now. Professor Lee, are you there?
Yeah. Yes.
Thank you. Please take the floor.
Good afternoon. I'm Jae-hyung Lee of Korea University School of Law. I'm in charge of moderating the first session of this wonderful seminar. For the last 13 years, since 2009, I have been involved in climate change negotiations as a legal counsel to the Korean delegation to UN climate change negotiations. So I am personally very interested in the presentations which will be delivered in this session by three distinguished scholars. I'd like to start this session with expressing my sincere gratitude to the Korean Ministry of Foreign Affairs, ITROS, and the Korean Society of International Law, which organized this wonderful conference and invite me as a moderator. We have three speakers and two discussants for this session. I was asked to assign 20 minutes to each speaker and 15 minutes to each discussant. The remaining time, about 5 to 10 minutes, will be used for additional comments and further discussion among speakers and discussants. Having said that, let me invite our first speaker, legend Professor of Law, Daniel Michael BODANSKY from Arizona State University. He wrote The Art and Craft of International Environment Law, which received the 2010 Harold and Margaret Spratt Award of the International Law Association as the best book that year in the field of international environment studies. His recent book, International Climate Change Law, co-authored with other scholars, received the 2018 Certificate of Merit from the American Society of International Law as the best book in a specialized area of international law. The title of his presentation today is The Role of Ocean Law in Responding to Climate Change. Please welcome him, Professor BODANSKY. You have the floor for 20 minutes.
Well, thank you very much. It's a great pleasure to be here. And I want to thank our hosts, the Korean Ministry of Foreign Affairs, the Korean Society of International Law, and ITLOS. And I also particularly want to thank the Secretariat for all the arrangements they did to get me here. It's a great pleasure to be able to be here in person. It wasn't an easy task, and I want to thank them for all their help. So thanks. I have spent most of the last 3 decades on climate change law, but I actually began working on law of the sea. So it's a particular treat to be back here hearing about the law of the sea, a topic that I started with but haven't really been focusing on as much in my more recent career. And my topic today is the role of ocean law in addressing climate change. Like some of the other presentations that we've heard, this grows out of a chapter I wrote for the book Festschrift for David Freestone. That one focused more on the climate change regime side of things, and this is going to focus more on the ocean law side of things. So my talk has 3 parts. First, I'm going to be describing the impacts of climate change on the ocean. Then in the second part of my talk, I want to discuss a little bit the appropriate division of labor between the climate change regime, climate law, and ocean law. And my basic point here is going to be that I think really, if we're talking about mitigation of climate change, that is reducing emissions to prevent climate change from happening to the extent possible to limit it, then that's primarily the role of the climate change regime. When we're talking about adaptation, ocean adaptation, that really, I think, is the primary role of ocean law with respect to climate change. And then third, I'm going to then be focusing on ocean law and adaptation and discuss a little bit how ocean law can address the issue of adaptation, in particular looking at marine protected areas and their role and fisheries law. So just to begin, to review, probably a lot of this is familiar. What is the impact of climate change on the ocean? And it's really a triple threat. It is going to be warming the ocean, it's it's acidifying the ocean, and it's deoxygenating the ocean. So in terms of ocean warming, the ocean absorbs, as a huge benefit to the climate system really, because it absorbs more than 90% of the added heat that we're putting into the atmosphere as a result of fossil fuel emissions. And as a result, the ocean is warming up. Sea surface temperatures now have increased by about 0.5 degrees centigrade since 1980. In addition, the ocean is providing a benefit to the climate system by absorbing about 1/4 of all anthropogenic emissions of carbon dioxide. And that again then is having deleterious effects on the ocean in acidifying it. And the ocean surface is now about 30% more acidic than it was 150 years ago. Climate change is also contributing to deoxygenation of the ocean. Deoxygenation has a number of different causes, but about half of it, as I understand it, is a result of the warming of the ocean, because warmer water is less soluble for oxygen and can contain less oxygen. And then that has, of course, effects on marine life. And these aren't just, these effects we already are seeing now, but of course they're going to continue to get worse into the future. How much worse depends on how well we do in terms of mitigating climate change, in terms of limiting emissions. But in all of these metrics, ocean warming, ocean acidification, deoxygenation, the trend lines are not good looking forward to 2100. Now, these three impacts on the oceans, warming, acidification, oxygenation, then have a series of cascading effects, and I want to just briefly go over some of these different effects. Of course, the one that's most familiar is sea level rise. Sea level rise already is taking place and will continue well into the future, inundating coastal areas, in some cases possibly submerging islands, changing, well, an issue then, what is the effect of that on maritime baselines and ocean zones, something I'm not going to be addressing today. Global warming is also likely to be affecting ocean circulation patterns. So ocean circulation patterns are likely to change as a result of the warming of the oceans. There are extreme heat events. So there's just a general warming, but of course there are unusual events. And this was one unusual event, sometimes referred to as the blob, between 2013 and 2015, when there was a huge increase in warm waters in the eastern Pacific Ocean off the coasts of British Columbia, Washington, California. These effects are then having knock-on effects in terms of marine life. The distribution of species is changing. Species are moving northward to get to colder water. As the water warms up, they're moving deeper into deeper water that's cooler again. So both in terms of the depth at which species are found and the latitudes at which they're found, that's changing as a result of climate change. This is going to then lead to a redistribution of fisheries, basically northward as fish stocks move northward and southward towards the poles, towards higher latitudes to get to cooler water. Another effect that's well known, coral bleaching, both as a result of warmer waters and as a result of ocean acidification. And then finally, some effects on marine mammals and seabirds, in part due to disappearing ice. So mammals that are dependent on ice as the ice disappears in the Arctic then are going to be threatened. The impacts of climate change on the ocean are not evenly distributed around the world. Different oceans are going to be differentially impacted by these different effects. And this is from the most recent IPCC report showing the distribution across different oceans of different effects. Now, I think it's probably hard to see up there on the screen, but you can see that in some ocean areas, there's some effects that are seen in other ones, and those effects don't occur in all ocean areas. The different dots show the certainty with which scientists have about the likelihood of these effects. One thing, though, we do know pretty much for sure is that the warmer the world becomes, the more severe the impacts are going to be. The more severe they're going to be on land, but also the more severe they're going to be on the ocean. So the vertical scale there is increasing temperature change, and then the colors are showing the severity of the impacts, and you can see 2 degrees worse than 1.5, 3 worse than 2, and so forth. So the more we can limit climate change, the more we can then limit these various impacts on the oceans. Now, despite the very large effects that climate change are going to have on the ocean, climate and ocean governance have been largely disconnected throughout most of the history of the climate change regime. This has, though, I think, begun to change significantly, beginning with the Monado Declaration back in 2009 during the World Ocean Conference. There's been increasing attention given to the ocean at climate change meetings with Ocean Action Days at the various climate COPs beginning in 2009. Chile had the Because the Ocean Initiative starting in 2015, the Ocean Pathway Initiative of Fiji in 2017, and then the so-called Blue COP that was going to be held in Santiago in Chile, but then was moved to Madrid, a COP that was focused much more on the ocean than had been the case with previous COPs. Most recently at the Glasgow conference, there was a decision as part of the Glasgow Climate Pact to establish a yearly ocean climate dialogue. So ocean climate issues are now going to be a regular part of the discussions within the UN climate change regime. And we can also see this, I think, in terms of what countries are doing in their nationally determined contributions. The basic architecture of the Paris Agreement is that each country nationally determines what its contribution is going to be to address climate change. Now, roughly 70% of national NDCs include marine issues within them. And most of the ones that don't include NDCs are by landlocked countries. So almost all countries with coastlines now are addressing marine issues to some extent or another in their NDCs, either in terms of mitigation actions dealing with climate change or adaptation actions on climate change dealing with the marine environment. So what's the appropriate division of labor between ocean and climate change law now that both the ocean law and climate law are beginning to look at this ocean-climate interface? And my basic view, maybe this is just reflecting my own biases as a climate person rather than ocean person, but my point of view is that with respect to mitigation of climate change, with respect to reducing emissions to limit climate change, to prevent temperature increase, the primary regulatory role is the UN climate change regime, is the UN Framework Convention on Climate Change, and then its subsequent instruments, most recently now the Paris Agreement. It has the major role. With respect to mitigation, ocean law has a secondary role, primarily focused on ocean-based sources and sinks of greenhouse gases. With respect to adaptation, though, the situation, I think, is quite different, where, in my view, the primary role should be played by ocean law, with climate law playing a supportive role, primarily in terms of providing funding. And in terms of this division of labor, I'm looking at as criteria for deciding which of these two bodies of law is most appropriate for dealing with which set of issues. Congruence with the scope of the issue, to what extent can they deal with the issue holistically, participation by key states in the regimes, the regulatory competence of the two regimes, the two bodies of law, expertise, effectiveness, and political salience. So with respect to mitigation, the UN climate change regime, since its inception back in 1991, 1992, has been the major international body to address mitigation of climate change. And while I, for one, and I think most people are disappointed with the very slow progress that we've seen in the climate change regime, I've been now doing it for 30 years. And if you told me we would be where we are today 30 years ago, I would have maybe not continued in the field this long. But I think we have seen progress. I think it's too easy to say that the regime is failing because Actually, there's been significant progress over the last half decade, well, in the run-up to the Paris Agreement and then in the period since the Paris Agreement. So when the Paris Agreement was being negotiated, most people estimated we were on track to having more than 3 degrees of global warming. Now, as a result of first the pledges that were made in Paris, then the pledges that were made after Paris before Glasgow, then some new pledges made in Glasgow, we're now somewhere in the range of 2.1, and the most optimistic assessments now are down to 1.8 degrees of temperature increase. The Paris Agreement establishes the goal of well below 2 degrees, with 1.5 degrees as the aspiration. I think 1.5 now is really where the international community is focused in terms of what the goal of the climate change regime is. Obviously still short of that in the climate change regime. We're not there yet. And of course, these are just pledges. Whether countries will actually follow through on their pledges and reduce emissions, open question, remains to be seen. But I think we're seeing some significant progress in terms of what countries are saying they're going to do to address climate change. Countries have upped their NDCs, their nationally determined contributions for 2030, and now there's an increasing number of countries now representing the large majority of global emissions that have pledged to mid-century decarbonization targets, net zero targets by, when most cases 2050, in the case of China 2060, and now most recently India 2070. The Paris Agreement is also comprehensive. It addresses all sources and sinks of greenhouse gases. It addresses all sectors. It addresses all of the different greenhouse gases, with the exception of those regulated by the Montreal Protocol. It has near universal membership. Virtually every country now is part of the Paris Agreement and submits NDCs. It has significant expertise, obviously, particularly with the support of the Intergovernmental Panel on Climate Change, which puts out regular reports summarizing the science. And it has a huge degree of political salience, I think much more than any other international regime today. The amount of attention that climate change gets by the public, by the press, by leaders, I think is unique among international issues today. Glasgow, even in the US, where climate change doesn't get as much attention as it does in some places, it was the lead story every day of the Glasgow conference on the nightly news programs. A huge number of world leaders in Glasgow for the conference. Now, and I think really if we're thinking about saving the ocean, which is our focus here, the single most important thing that will save the ocean is for the Paris Agreement to be successful. That's the single thing, I think, that's going to be determinative of the fate of the ocean. And every bit that the climate change regime is able to do to reduce global warming, to reduce emissions, has a big payoff for the globe as a whole, but of course, including for the ocean as well. Now, what's the role of ocean law on mitigation? Well, I think clearly ocean law has a significant role to play with respect to ocean-based sources of emissions, and particularly ship-based sources of emission. And that's recognized in the climate change regime itself, where the parties to the UN Framework Convention have allocated emissions from shipping to the International Maritime Organization to regulate. And so those emissions are now being addressed, not terribly well, but to some degree in the International Maritime Organization. MARPOL, there was an amendment to MARPOL providing for ship efficiency standards that was adopted a number of years ago. Most recently in 2018, the IMO came out with a global goal of reducing emissions from maritime shipping by 50% by 2050. Now, that's still not aligned with what the international community now sees, I think, as necessary to address climate change, which is decarbonization. This 50% by 2050, but still it represents, I think, a significant step by the IMO. Why is ship-based emissions particularly appropriate for the IMO to address? The entire basis for the climate change regime is allocating emission reductions territorially. Ship-based emissions, of course, take place outside of national jurisdiction. They're very difficult to allocate on a national basis. So dealing with it on a sectoral basis through the IMO, I think, makes the most sense. Could ocean law play a role in promoting mitigation more generally? And I think a lot of people now are thinking, well, the answer to that is yes, that maybe ocean law could also play a significant role, not just in addressing ocean-based emissions like emissions from ships, but also to address emissions of greenhouse gases more generally. I think it is the case, and I agree with those who've said this earlier in this conference, that carbon dioxide emissions is a source of marine pollution. It fits the definition of marine pollution in the Law of the Sea Convention. It's the addition of energy and substances to the marine environment with deleterious effects. So it is covered by the Law of the Sea Convention. But I think the thing is, and at least this is my view, and I have a little skepticism here, I guess, of what ocean law could do to address emissions generally. The rules, the standards for pollution in the UNCLOS, I don't think go beyond the standards that we already have in international environmental law more generally, in the Paris Agreement. I think the issue of emissions mitigation is much more specifically addressed in much more detail in the UN climate change regime that is addressed now in the very general rules in UNCLOS. Now, it is the case that UNCLOS, unlike the climate change regime, has mandatory dispute settlement. I know there's interest now in bringing requests for an advisory opinion. I guess count me skeptical, though, as to how big an effect an advisory opinion would really have in terms of changing emissions. There's so much attention to climate change at a very high level through the climate change regime that I think the marginal impact, in my view at least, would be modest. Now, let's turn to adaptation. I think the situation with adaptation is quite different. In order for the ocean to adapt to climate change, the basic approach is to, if climate change is occurring, there's warming, how does the ocean adapt to it? The basic approach is to reduce other stressors to the marine environment. Overfishing, marine pollution, negative effects from navigation, habitat degradation. These are issues already regulated in ocean law, and so ocean law is already available to address these other stressors in order to try to adapt to climate change, either through activity-based limits, like limits on pollution, such as those contained in MARPOL, area-based limitations, things like nature reserves, wilderness areas, or hybrid approaches where you're limiting particular activities in particular areas, like particularly sensitive sea areas where there are limitations on navigation in particular areas that are environmentally sensitive. I think there also is a role on adaptation, marine adaptation in the climate regime. So a lot of NDCs now under the Paris Agreement, nationally determined contributions, do deal with adaptation in coastal areas. So in coastal waters, individual countries can take a lot of measures to try to adapt to climate change. But a lot of adaptation is going to require cooperation between states. It's going to go beyond what individual states can do. And you have available in the ocean regime a large number of different instruments, both global instruments like MARPOL, London Convention, London Protocol, International Whaling Convention, and so forth. And then you also have various regional instruments, both the regional seas agreements under UNEP and the regional fisheries management organizations and arrangements. Now, let me talk just briefly about two different ways to try to adapt to the adverse effects of climate change on the ocean. One is through marine protected areas and other area-based management tools. The marine protected area seems to be an umbrella term and encompasses a lot of different things with different legal bases and levels of protection. But I think basically the concept is to have higher levels of protection in a geographically defined area. And I think, as I understand it, what distinguishes marine protected areas from other area-based management tools is that marine protected areas tend to be more holistic. They try to be more look at the entire range of stressors in a particular area rather than more activity-based like particularly sensitive sea areas. Now, marine protected areas can be an adaptation tool to climate change by focusing and reducing other stressors on the marine environment. So you can try to protect coral reefs against global warming and acidification by limiting fishing, by limiting nutrient pollution. You can try to protect seagrasses by protecting them from anchoring and nutrient pollution. So you can try to reduce the other stressors in sensitive areas through marine protected areas to make them more resilient, to climate change. Now, UNCLOS provides some basis for the creation of marine protected areas. It doesn't explicitly provide for them, but Article 194 provides for measures necessary to protect and preserve rare or fragile ecosystems. Of course, those need to be then also consistent with the rights and duties of other states in the marine area and the sea. The ability, the jurisdiction of states to create marine protected areas under UNCLOS varies, of course, on a zonal basis. In coastal waters, much more authority. On the high seas, the only authority is for flag states to restrict their own vessels or to restrict other vessels under the terms of a treaty to which both states are parties. So marine protected areas up until now, of course, primarily have been done within coastal waters. In the EEZ, coastal states can create marine protected areas limiting fishing, but to restrict navigation, they need to go through the IMO under Article 211, paragraph 6 of the Law of the Sea Convention. There are quite a few now different treaties that provide some basis for establishing high seas MPAs. The IMO can create particularly sensitive sea areas. MARPOL can create special areas, and that's been done in a number of cases. CAMLAR has created protected areas. Various regional seas agreements provide for the establishment of protected areas. I actually met David Freestone many years ago when I was a U.S. negotiator negotiating the Specially Protected Areas and Wildlife Protocol to the Cartagena Convention, the Caribbean Convention. The BBNJ Treaty, which we've just been hearing about in the previous session, would provide a much more general basis for the establishment of high seas MPAs, and that's one of its primary purposes. And here, this is just a map showing some of the marine protected areas that have been created under MARPOL, under the various regional seas agreements in Europe, the PSSAs by the IMO, and in Antarctica by the CAMLAR Convention. Now, and most recently, there's been a move to increase the target under the Convention on Biological Diversity to protect 10% of the marine environment by 2020, a goal that actually was not met. But to up that goal to protect 30% of the marine environment by 2030. So countries are not discouraged by the fact that they failed to meet the previous goal and now are talking about having a much more ambitious goal, and that's likely to be adopted in March 2020 at the next Convention on Biological Diversity COP in China. These special protected areas, though, or these marine protected areas, to be effective in dealing with the climate change issue, need to be designated keeping in mind climate change impacts. So you need to try to designate areas that are not vulnerable to climate impacts, or that are vulnerable, but where the vulnerability can be significantly reduced by protection, by limiting other stressors on the marine environment. The problem is that despite the fact that there are quite a few MPAs that have already been created, there's very little evidence that the climate change is actually taken into account in the designation of marine protected areas or in the management plans. Only a little more than half of MPAs established since 2010. So 2010, when climate change was already a huge issue on the international agenda, even mentioned climate change in their management plans at all. So I think there's the potential for the 30 by 30 target and for the BBNJ treaty to allow for the creation of significantly more marine protected areas. The question is whether in creating those marine protected areas, they will adequately take climate change into account, whether they will be actually used effectively to deal with the adaptation to climate change. To have more climate-oriented MPAs, I think MPAs are going to need to be more forward-looking. The designation of MPAs needs to take climate change impacts into account, needs to look at future conditions as resulting from climate change. We need more of a network of MPAs, not just single MPAs, to allow migratory species to migrate from one area to others as the oceans warm. We need a more holistic approach, so I think we've heard a lot about holistic approaches already. We need a more holistic approach to management that are going to be able to take into account cumulative impacts on the marine environment, including those from climate change. So we need to identify vulnerability to climate change. We need to set objectives that take climate change into account, and we need to develop strategies within MPAs to address climate change. Now, I'm not an expert on the BBNJ agreement, so our previous panelists from the last session would be much better able to answer this question than I am. But my read of the BBNJ treaty, the text that now is before countries, is that it's beginning to take some baby steps in this direction, but maybe still has a long way to go to fully integrate climate change into its provisions. So part 3 deals with area-based management tools, so protected areas. The draft objective, one of them is to build resilience to stressors, so that's all to the good. The draft indicative criteria, one of them that's been identified, is vulnerability to climate change and oceanification. So there's some things in there that I think are positives. The EIA section does provide for states to take account of cumulative impacts, but I think there probably is still a lot more to be done to try to fully reflect climate change within the BBNJ process. Turning finally to fisheries, and I'll end there. Fisheries, again, relatively late to the party with respect to ocean climate interface. FAO didn't initiate work on climate change in fisheries until 2007. The first UNGA Sustainable Fisheries Resolution that mentioned climate change was also in 2007. The fish stock agreement does provide some basis for taking climate change into account, because it does say that management measures should be qualified by relevant environmental factors, so that would include climate change stressors. It also references the precautionary principle, which we heard about yesterday. The review conferences for the fish stock agreements increasingly have focused on climate change within the resolutions, and in the 2018 resolution, the resolution urges states to address the uncertainties and changes such as those related to climate change, and calls upon states and our regional fishery management organizations to take into account potential impacts of climate change and ocean acidification. Nevertheless, a study recently by Rosemary Rayfuse looking at regional fishery management organizations found that it's very difficult to gauge to what extent RFMOs are actually taking climate change into account. There's little evidence, she said, to suggest that RFMOs are explicitly absorbing climate change into their decision rules for things like allocations of stock takes, catch allocations. So again, I think there's a lot of work to be done in the ocean regime to better address adaptation to climate change within the fisheries system. Some recent developments. One of the problems is that a lot of regional fishery management organizations require consensus, difficult to get consensus. In CAMLAR, proposals for a work program on climate change a couple of years ago were blocked by China and Russia. I think one positive development was agreement by 10 Arctic states to create a Central Arctic Ocean Fisheries Agreement, which will prohibit unregulated fishing in the high seas portion of the Arctic Ocean, I think for 16 or 17 years, and then it's going to be reviewed again. Looking forward, I think fisheries management needs to anticipate and take into account climate stressors much more than it does today. It needs to adopt a much more precautionary approach given all of the uncertainties about the effects of climate change on fisheries. And it needs to be much more flexible to be able to, it's based on sort of assumption that things are more or less stable, but things are not stable in the ocean as a result of climate change. So the fisheries management organizations need to take a much more flexible approach. One thing that's, I think, a particular challenge is that as fish migrate, the jurisdictional reach of different regional fishery management organizations may no longer match where the fish actually are located. So that's going to require cooperation between different RFMOs to try to address species as they change their geographical distribution. So a lot of challenges, I think, both on the MPA front in trying to make MPAs more relevant to climate change, better equipped to be able to help the ocean be able to adapt to climate change, and also a lot of work to be done in the fisheries management area to again address the impacts of climate change on fisheries. So with that, I will conclude and look forward to discussion later. Thank you.
Thank you very much, Professor BODANSKY.